In the film Boots on the Ground, the Twin Cities No-Kill Story, Minneapolis City Council member Cam Gordon mentions the link between killing in animal shelters and old, outdated policing practices, which are strongly tied to systemic racism. Racist practices and policies in animal shelters are in fact strongly correlated to killing in animal shelters, with shelters doing the most killing having the most racism in their systems. It's a topic that could be made into its own film. In fact, the very first interview I did for Boots on the Ground, the Twin Cities No-Kill Story, was with Twin Cities-based attorney Marshall Tanick, whom I've known for about 20 years. Marshall and I have worked together litigating against puppy mills and on a host of other animal welfare topics. Marshall has successfully sued multiple municipalities, challenging breed bans, fighting arbitrary dangerous dog ordinances, and advocating for pets of people who've gotten caught up in overly bureaucratic and often lethal animal control operations. I interviewed Marshall for the film before Minneapolis transitioned to no-kill, and because of their successful transition, his interview was no longer as pertinent to the film. But in the proper historical context, the information he provided was incredibly meaningful, so I'm presenting his interview in its entirety here. Marshall spoke on systemic racism, breed bans, and the arbitrary and ambiguous way dangerous dog laws are often enforced.
I got into the dog legal industry way back in the mid-1980s. I was approached by the daughter of a Supreme Court justice at the time who had an interesting problem that she wanted to talk to me about. And her father referred her to me, not as a dog lawyer, because there wasn't really a lot of animal law developed at that time, but the judge knew that I did a lot of constitutional work, and the issue was a breed-specific ban, which had not been challenged very much, and certainly not successfully in the courts at that time. Minneapolis in the mid-1980s had enacted a breed-specific ban directed only to pit bulls, and it emulated some breed bans that were being implemented in other parts of the country. I took a look at it and recognized that there were some real difficulties with that statute, the vagueness elements of it, and other deficiencies, and we challenged that breed ban law in the court in Minneapolis. And ultimately the case went up to the Minnesota court. We won at the trial court level. It was appealed to the Minnesota Court of Appeals, and we won at that level too. And that set a nationwide precedent. It really was a sea change in breed-specific legislation and litigation. Until that time, what sparse cases there were had upheld breed-specific bans, mostly directed at pit bulls. We argued that it was unconstitutional to do so on a number of grounds. It wasn't fair, equal protection, due process, but the linchpin of the case, and I think the thing that got the most attention around the country, was we brought in 21 different photographs of different dogs. We were planning on bringing the dogs themselves in, but the judge wouldn't let us do that. So we brought in these big blow-ups on posters of 21 different dogs, and during the trial we had the animal control officers from Minneapolis who were enforcing the law in Minneapolis try to identify which ones fall within the breed-specific ban, which ones are pit bulls and which ones aren't. And it was interesting that the three animal control officers had markedly different testimony about which category of dogs these fell into, or which categories of classifications these dogs fell into. So they weren't even able themselves to identify what constitutes a pit bull versus some other kind of dog. And as a result, the judge said the law was too vague and ambiguous to be enforced. That, as I said, was an important ruling. And when the Minnesota Court of Appeals affirmed that ruling, it created a precedent that ultimately resulted in many breed ban specific laws around the country being either repealed or rolled back, including the Minnesota legislature then passed a statewide law that prohibited breed specific bans on particular dogs.
Talk a little about how animal control, was labeling dogs as pit bulls, and ultimately the court decided their labeling was arbitrary. Can you talk a little
Yeah,
about?
I mean, that was the key to the case, is that the way that the law was enforced was arbitrary and capricious and too vague to be intelligible. And I'm not sure to this day how they were labeling the dogs, and they're not either, and that was the problem. They had no specific standards, they had no specific guidelines. It was pretty much at the discretion or whim of which particular animal control officer was involved in a particular situation. And one element of that case that got some attention, it wasn't real developed, and it probably could have been, but we didn't go too deep into that direction. We should have, but we went on other grounds, was there was a racial element to it, and certainly an economic class element to it. The implementation and enforcement of the anti-pit bull laws was much more pronounced in poorer sections of Minneapolis and against particular races versus other ethnic or racial groups. Put it another way, the African Americans and poor people generally were much more subject to enforcement than other people.
I'm finding that, and many people are telling me the same is still true today in terms of dangerous dog designation.
Absolutely, yeah.
Can you talk a little about that?
Sure, yeah, and that's why I mentioned that, because the issues over breed-specific dogs have pretty much faded into the background, as I said, because of our case and some other cases. That issue is not a front burner issue as it was 20 or 30 years ago. But the same elements and same issues keep arising in different contexts because Minneapolis Animal Control keeps moving the goalposts. And when they move the goalposts, like Lucy and Charlie Brown, they take the football with them and move with it. In other words, the ways that they've enforced other laws, like the breed-specific ban, are translated into how they're enforcing dangerous dog laws. And there's a definite racial and economic and class element to it. Now that's true of a lot of laws, quite frankly. Drug laws and other laws tend to be more harshly enforced against particular, more vulnerable people, particularly those who can't afford or can't obtain legal counsel. And I'm working with an individual right now who's trying to put together anecdotally some statistics in Minneapolis and other communities to show the disproportionate way that dangerous dog laws are enforced as to racial minorities and as to poor people. And it's not surprising, as I told this individual with whom I'm working, she was quite aghast at some of the initial preliminary figures that we've developed, and I wasn't, because I said most laws work that way too. Speeding laws are another example. I had a class action case. This isn't about dogs, but I think it makes the point. I was involved in a class action case about 10 years ago concerning Minneapolis adopted the particular program where they had these red lights at particular intersections with cameras, and if people's cars went through the red lights, they got an automatic ticket without any law enforcement involvement. The idea was to save money, but they also ended up, because they had a very cheap system, it was a very defective way to picture cars, and there was a lot of shortcomings in the program. And we brought a class action to throw out all these tickets and give refunds for 14,000 people who had been improperly ticketed. But what was notable about that case is that they set up 8 traffic centers to impose these automatic tickets for people, and 6 of the 8 were in the inner city of Minneapolis. Again, I think that's emblematic or symptomatic of how cities enforce sort of cultural and way of life measures. They tend to be easier to enforce against more vulnerable people. That's true with dog laws as well.
So you said previously that there was an arbitrary way that animal control was designating dogs to be so-called, quote unquote, pit bulls. Can you and that they've carried that sort of philosophy forward a little bit. Can you talk a little bit how the way they designate dogs as dangerous or potentially dangerous remains arbitrary? If you think it is.
I think it is. I think it's not quite as bad as with the pit bulls, but that's not to exonerate the city at all. The one reason it's not quite as bad is because there usually is some type of physical contact involved. So it's the arbitrary nature of it is somewhat muted, but still pronounced. And I think some of the ways that the arbitrary and capricious nature of these enforcement measures take place is whether the severity of the injury, oftentimes a very small nip on an ankle, can be elevated by animal control authorities into some kind of confiscatory policy against dogs, and that's usually enforced against poorer people who can't fight back. They'll cite the dog, they'll bring the dog in for confinement, they'll quarantine the dog, and if the person isn't able or capable or articulate themselves or able to secure legal counsel, they find themselves just getting trapped in the system. So the nature of the bite can be one factor. Second one is the interaction between multiple animals. And I find, in my experience, Mike, that more than half, and probably close to 3/4 of the dangerous dog cases that I see are cases that arise out of some scuffle between two dogs or more dogs. And many of them are quite innocuous. Most of them are quite innocuous. Someone will be walking their dog, and another dog will come by, and the dogs will get in a little bit of a scuffle, and the next thing you know, someone calls the police, and there's a dangerous dog citation. I'm not saying those aren't significant situations, but they could be handled in a much more ameliorative way, rather than dealing with imposing sanctions and taking dogs away from people and creating large fines on people. And also, under the law in Minnesota, it's basically a two-strike law. If your dog is once cited for a dangerous dog incident or potentially dangerous, the next time it happens, the dog is subject to possible execution. So there's a lot of adverse consequences that flow out of a relatively innocuous situation, and those tend to be imposed more on poor people. And quite frankly, there's a parallel between being poor and being a racial minority.
Can you talk about one of the most extreme cases of dangerous dogs that you've seen? You know, a case where just it seemed ridiculous that animal control.
Well, I can think of one in particular. It was a while ago, and in that case, there simply was no bite at all. There was a report that a dog had bitten someone, and this was a scuffle case. Two dogs had got in an encounter in northeast Minneapolis, and the owner of one of the dogs called the law enforcement authorities and reported that the other dog had bit her. But there was no evidence of that. Nevertheless, based on simply her own word, without taking any pictures, without any evidence, they accepted her word and cited the other person for a dangerous dog. And they had to go to a hearing, like a mini trial. I represented them, and we were able to disprove that there was any bite at all. And the case should have never gotten that far. It cost the person some time off from work, it cost them some legal fees, and it cost them a lot of anguish to fight a case that should have never been brought. So the fact that my client won the case was gratifying, but nevertheless somewhat unsatisfying, because it's a case that shouldn't have been brought in the first place. And what happened there is I pointed out to the authorities ahead of time how there was a lack of any evidence, and I said, please produce some evidence that shows there was a bite here other than one woman's statement, which was unverified, and they couldn't and wouldn't do it. And that's a case where they brought on themselves the agony of having to go through a trial that was unnecessary.
Usually it ends up being the dog owner who ends up footing the legal bills.
Oh, well, not usually, always. With very few exceptions, when a dangerous dog citation is given out and an owner has to fight that either through the courts or through some administrative agency, the owner has to bear the legal costs. And that's generally true of our legal system as in most cases. There are some exceptions. There's a general rule: an individual who's caught up in the legal system, even if they're exonerated, has to bear their own legal costs. Now, some people have said, well, that's not fair. We should have a loser pays system. Some countries do have that. Not too many countries even have a civil law system like ours, but England and Canada do have what's called loser pays systems. In those situations, if someone engages the legal process in a civil lawsuit and they lose, they are theoretically required to pay the other side's legal fees. And that sounds pretty fair to a lot of people, and they say we ought to have that kind of system here to beat down frivolous lawsuits and prevent people from suing. I think it's a real bad idea. A lot of important social change has been brought about through lawsuits by people who don't have a lot of money and perhaps were facing long odds and trying to reverse legal precedent. And if they were faced with the prospect of, hey, if you bring a lawsuit and some judge doesn't like the lawsuit and rules against you, you can be bankrupt. That'll stifle people from using the legal system. The big and powerful people aren't going to be deterred from using the legal system under the loser pay system, but smaller, more vulnerable people will. So imagine what would happen if we had a loser pay system and someone wanted to challenge racial segregation or unfairness against lesbians and gays. And those people would be facing the prospect, their lawyer would have to tell them, well, if you lose this case, you're going to have to pay the other side's legal fees. They may not bring that case, and they may not bring about social change. So I think the loser pay system, while it sounds congenial and a good way to handle the legal system, isn't a very good idea. However, in some cases, it would be a good idea, and for people who run into problems with dangerous dog situations and ultimately are exonerated or prevailed, there probably ought to be a system that allows them to be reimbursed for the legal fees they incur, because those people generally have a great difficulty finding lawyers. There's not a lot of lawyers who do these cases, and because there's not a lawyers who do these cases, the fees aren't that competitive. You can't shop around for the lowest fee. You end up paying whatever the lawyer wants to charge, and the lawyers are pretty fair about it. I certainly am myself, but nevertheless, challenging a dangerous dog designation, depending upon how intense and vigorous the case is, can cost anywhere from $3,000 to $5,000 at the first level. I've had a couple of cases where we've won at the Supreme Court. We had to go through 3 different courts to finally win, and it cost well into 5 figures. Fortunately, those people were able to afford most of those legal fees. Most people can't.
And did you prevail in them?
Yeah, we prevailed in the cases, but they were to some extent, they were Pyrrhic victories because they were financially ruinous to the individuals who won. And what if they wouldn't have won? And as anyone who engaged in litigation knows, you don't win them all. And when you lose a case, there's a double whammy. You lose a case and you have to pay a lot of fees for the privilege of losing. Even if you win, it costs a lot. No one reimburses you for those.
There was a story that you told on Animal Wise Radio years ago about a case that you had where you had a client whose dog was attacked by another dog, and there was the dog that was attacked was deemed dangerous. Can you talk? Do you remember that case? Can you talk about that?
Yeah, I've had a couple of those. As I said, most of the dangerous dog cases I see are dog scuffle and their dog encounter cases. And I'm not sure I remember that specific case, but that syndrome exists. I've had at least 2 or 3 cases I can remember where the perpetrator or the aggressor dog was not cited, and the dog who was the victim was cited. It's a little bit like in sporting events. Sometimes when there's a fight or fisticuffs in a sporting event, the referee sees the second person who was involved, didn't see the first punch being thrown, but sees the second punch being thrown, and it's this person who fights back who ends up being cited. That's a little bit like the dog situation where the aggressor dog gets away with it, but the secondary dog, who's the victim, ends up being cited. And that's happened on a few occasions. And fortunately, in the ones that I've been involved in, we've been able to get the dog cleared or acquitted of the charges, but nevertheless, they've been expensive. And apart from the legal expense, there's another expense, and that's the emotional toll it takes on dog owners, which is substantial.
What do you think that Minneapolis Animal Control could do to alleviate the impacts on poor minority people, or maybe make the designation process less arbitrary?
Well, one thing is to realize that what the problem is. I think that many animal control authorities, including Minneapolis, are quite arrogant in how they go about enforcing laws. They have a real, they feel they run a fiefdom, and they have almost unlimited jurisdiction and power, and they exercise it. And I think they have a little bit more humility to recognize that occasionally we do make mistakes, and we ought to listen to what people are telling us. A little bit of humility would be helpful as a starting point. Secondly, having open-minded people listen initially when a presentation is made can probably stave off a lot of the more vigorous, intense, deep-seated litigation. As I said, oftentimes there's an innocuous explanation for these dangerous dog situations, and if people are willing to listen, pay attention, and actually give the matter some thought rather than act reflexively, I think they're going to serve the public better. A third feature is one could come up with some type of legislation if the elected officials and the public feels is necessary to set up some kind of fund or some kind of mechanism to compensate people whose dogs are wrongly charged as being dangerous. And I think having even a system in place like that will make the authorities more hesitant to engage in reckless or overly aggressive charges, knowing that if they're wrong, they may have to incur some legal expense. So having those kind of systems in place, I think, would have a significant positive impact on the enforcement of dangerous dog laws, which I think are important. I think we need dangerous dog laws, and we need them to be enforced, but we need them to be enforced fairly and impartially.
Can you give a general assessment of the city of Minneapolis animal control practices relative to the other animal control in and around the area? Like, do you see the same kinds of issues as much in other communities?
No, I don't, but I mean, just statistically, Minneapolis has many more dangerous dog and related cases. Now, part of that is because it has a greater population, but even if you add up the populations of all the surrounding areas. And I did one year, this is about 5-6 years ago, I did that. I did a somewhat informal study, and it appeared that Minneapolis alone had more dangerous dog cases than all of the surrounding communities that had greater population than Minneapolis. A part of that is because of the nature of the city, perhaps. There's more dogs in the city, but they have a more aggressive approach to this. That's not in and of itself bad, but I think it's reflective of the fact that in many other communities, suburban communities in particular, the authorities are much more willing to listen to people, take the people's views into account, and come up with solutions that are less draconian than dangerous dog charges. And I get involved in a lot of those kind of cases with many of our first and second ring suburbs, where I'll talk to the authorities, say, okay, here's a problem, here's what we propose. We'll have some obedience training. We will do some protective measures. We'll put some signage in the yard. We will do things that are somewhat conciliatory, but without necessarily having to incur the wrath of a dangerous dog citation, which not only is detrimental to the dog and the family, but it also can have some significant impact on insurance rates, insurance availability, and that's a real problem too. Insurance companies will oftentimes shy away from extending homeowners insurance or will charge an extra premium if there's a dog, or if there's a dog that has a dangerous dog citation or dangerous dog record. And oftentimes those dangerous dog records can arise in Minneapolis, at least, out of innocuous situations. So in answer to the long answer to your short question is, Minneapolis, I think, is much more reactive and overly reactive to relatively small incidents. In fact, there's kind of an unwritten rule of law that I see being enforced, is if there's any complaint at all, the authorities are usually going to issue some kind of citation, in part to appease the complaining party. And I think it's a quality of life issue too. And generally, they have the support of the elected officials. Dog issues and dog bite issues and dog barking issues are a major issue of concern to members of local communities and elected officials, city council people, and understandably so. And they're not that much engaged in matters of world peace and the value of the euro and whether the interest rate should go up or down at the Federal Reserve. They hear most complaints about quality of life issues, and dogs are a major issue to legislative officials, and generally they don't side with the dog owners. If someone complains, they want some action taken to appease the person who's complaining. Now that may be good politics, but oftentimes it overlooks looking at a situation from an impartial, two-sided viewpoint.